Over the past few months, there's been much public debate as to whether alleged terrorists being held in Guantanamo Bay should be brought before military trials or civilian criminal courts. What are the potential pitfalls if the Obama administration decides to pursue these cases before military tribunals?
The first potential pitfall is that it's totally unconstitutional, so any result will probably be reversed by the Supreme Court in the fullness of time. I think in order to answer your question, you really need to go back a little bit. Under the U.S. Constitution, a war is a very unusual circumstance. The authorized use of military force, which is what we have here, is not in unusual circumstances. We authorize use of military force against drug dealers, against the Barbary pirates long ago, against slave traders, against the whiskey rebels when George Washington led the army out of Washington and then Alexander Hamilton got on his horse and left George Washington in his carriage. But all those were the use of the military to do things that the president appropriately wished to have accomplished. None of them were a war. When the whiskey rebels were caught, they were brought to a trial. Pirates are brought to a trial, just like the pirate whom we captured off Somalia a few months ago. The framers thought a war was something with a country that could be ended by a treaty, and so the British ended their war against us with a treaty. We would have ended the war with the Confederacy with a treaty, and that's very unusual. The reason it's designed to be very unusual is that war carries a number of frightening implications in terms of presidential power. One of them is the ability to use military commissions. Another one, which is even more serious for Guantanamo, because only 10% of the people there are being thought of as candidates for military commissions, 90% are going to be held, according to the administration, until the end of the war. Well, that is something you can do with a prisoner of war if there is a war. It is not something you can do unless there's a war. And so you couldn't take the Somali pirate and hold him without charges, without proving anything, until the end of the war on Somali piracy, which, is somewhere off in the indefinite future. No, that's the whole reason why wars are very rare and defined events with a termination at the time of a treaty. None of that applies to the fight against Al-Qaeda. Therefore, the use of military commissions is improper, inappropriate, and unconstitutional from the beginning, and therefore, a stupid policy idea, regardless of all the distractions about procedural niceties that you might or might not get in the commissions. So much of the political debate in Washington proceeds on issues that are utterly peripheral to the fundamental and amazingly still unanswered issues here as to how there is any justification for proceeding under the laws of war at all.
So it sounds like there really is no precedence in American history for trying these types of prisoners before tribunals.
Not these types. There are one or two abusive instances in which, like the followers of the assassins of President Lincoln were brought before military commissions, which was probably not right. On the other hand, there is one excellent Supreme Court precedent on this. The Confederates were trying to break off Southern Ohio, which had a lot of pro-Southern sympathy in it. So, just the same way that the Union had gotten West Virginia to secede as a separate state, as a free state, the Confederates thought they would get Southern Ohio to secede as a separate state, slave state. And so they found a person to be governor, and they found a person to be military commander, a guy by the name of Milligan, and they gave him $100,000 in gold, and he was going to be the military commander of this new. But he was arrested by the Union Army and put on trial before a military commission, which sentenced him to be hanged. And the Supreme Court reversed all that and said the courts were open there. There's just absolutely no justification for doing anything than treating a plot to bomb the Union fortifications and military installations in the area as the first act of the uprising, then a conspiracy to blow up government property. So try him for that. The fact that we deal with that in our ordinary court system is a tribute to the kind of country we have, just as the fact that all aliens in the United States are entitled to fundamental rights. If someone's here from London, you don't have to give them the right to vote, but you can't torture him. And that's a level of fundamental rights that we insist on for our citizens abroad. And the right to be tried for a criminal offense is certainly in that category. And it makes sense for any number of reasons. One is that what the government says is true isn't necessarily true. Think about Dr. Wen-Ho Lee. He'd still be in Guantanamo if that system had been in effect at the time he was, in fact, released with an apology, or Brandon Mayfield in Oregon. The government is wrong sometimes, whether it's about anthrax or anything else, whether through malice or ignorance. What's legally required and makes good sense as a matter of city on a hill example to the world coincide not by coincidence. That's why they wrote the Constitution that way. They wrote the Constitution knowing that it was an idealistic form of government which had not existed in the world up till that time. There was no model of constrained government power remotely like what the Americans did. And it's worked, and I hope it will continue to work if the successors have the good sense to keep it. That this is not a legal matter or a court matter. The people will get the Constitution they want. As Judge Learned Hand said during the middle of the Second World War at a naturalization ceremony in Central Park to mass group, liberty lies in the hearts of men and women. And if it's there, the Constitution will conform, as we've seen in Supreme Court battles and other things. If it's not, then it won't matter what you've got written in your Constitution. And so really, as an educational matter, at Hofstra Law School and everywhere else, probably the most important thing we transmit is a system of values. I mean, I don't care how my students believe any particular case should have come out, but I certainly do want them to understand why we have these underlying concepts of separation of powers, freedom of speech, due process, so that they can carry it forward not only into their careers as legal professionals, but into their lives as citizens in their community.